A settlement, first of all, is a circumstance where both sides have their issues and there's some agreement reached that's in the middle. Settlements should be undertaken in a circumstance where you give the client as much information as you can. Here's what your case is about, here's what the law says, here's what we have to support our side of the case. But they also need to hear the other side of the case, because ultimately all of these issues get decided by a judge. And if a judge determines that we don't prevail, that's an outcome that is difficult. So a settlement encompasses educating the client first, and then kind of giving our best advice as to what we think. Do we think the case is really strong? Where are the weaknesses? What should we do? You need to lay out all that information for them. You need to do the calculations so they understand what the financial components are to a settlement. They need to understand what the future might be with regard to a settlement, because often there are circumstances where insurance companies are trying to be off the hook, as it were, with regard to future claims. And you have to be careful with regard to that. I don't have a crystal ball, doctors don't have a crystal ball, and the injured worker doesn't have a crystal ball. And when you're talking about a settlement which encompasses giving up something in the future, you really have to go into that kind of a decision with your eyes wide open.